and Tilbury 2 is the reconfigured lot at 5554 Tilbury.
Yes.
And you understand that Tilbury 1 is owned by Stewart and Marvel Feldman?
Yes.
And you understand that Tilbury 2 is is owned by Michael T. Kelly, trustee?
Yes.
And you understand that for all relevant times in the deposition, those were the owners of the properties?
Yes.
That is in all relevant times in this litigation dating back to 2008?
Yes.
And has it always been the position of the association that the Tilbury 2 lot could not be used as a single-family residence after the reconfiguration?
Yes.
But the association's position is that the Tilbury 2 residence must be torn down,
Correct.
and that it cannot be used as a single-family residence.
Correct.
And it's the association's position that it has not and it will not approve any improvements to the Tilbury 2 lot to facilitate its being used as a single-family residence,
Correct.
and that it won't approve any remodeling plans, correct?
Correct.
And it won't approve any new construction plans.
Correct.
You were provided the evidence the association was provided evidence in the fall of 2008 that Michael T. Kelly acquired the adjoining property, Tilbury 2, am I correct?
Correct.
The association was aware of the fact that Michael T. Kelly, trustee, acquired the Tilbury 2 lot, certainly from September or October 2008 onward, correct?
Correct.
And the association knew conclusively that Michael T. Kelly acquired the Tilbury 5554 Tilbury, which became Tilbury 2, in 2008, correct?
Correct.
So there's nowhere in the restrictions that there's a requirement of a platting, a replatting, or an amended plat in order to reconfigure the lot lines as between adjacent property owners.
Correct.
It's the association's position that nowhere in the restrictions does it say that a replat or an amended plat is necessary in order to reconfigure property lines.
Correct.
When I say reconfigure property lines as between adjacent property owners,
Correct.
is there anything in the restrictions of Tanglewood Homes Association that requires adjacent property owners to do anything other than agree among themselves to realign the common property line as between the two of them?
I'm not aware of anything.
And you would be aware of them because you're very knowledgeable about the restrictions.
I would think so, yes.
So I want to make sure I understand this. The association's position is that there's nothing else in the restrictions that requires adjacent property owners to do anything else other than agree as between the two of them on the realignment of a common property line.
Yes. There's nothing in the restrictions that deal with that.
But it's your position that the association requires an amended plat or a replat in order for that to take effect.
Correct.
And until that's done, it doesn't take effect,
Correct.
even though it's nowhere in the restrictions.
Correct.
When was the association apprised of the filing of the amended plat?
This is dated May the 22nd,
What year?
2009.
Who was the email to?
It was to me and Jim McCon.
Jim McCon is your attorney?
Correct.
Did you understand that this email apprised you of the filing of an amended plat when it was sent to you?
I didn't at the time, actually, but subsequently I did.
What part of the words amended plat on file with recorded by Harris County, which adjusted the property line between 5542 and 5554 Tilbury, was unclear to you on May 22nd, 2009?
It's not that it's unclear, I just missed it.
So the association was squarely apprised by May 22nd, 2009 of the filing of amended plat, correct?
Correct.
The result of the filing of the amended plat, according to the association, is that the property lines for each lot, 4 and 5, were reset, correct?
Correct.
And yet the association, am I correct, denied the request that was made in Exhibit W to build the fence?
Correct.
Why did the association deny the request to build the fence?
Because we had missed the fact that the amended plat had been filed.
Not only did you miss it, but your attorney missed it as well, right?
Correct.
The association was flat out wrong in issuing its fence denial letter. Am I correct?
Correct.
Even though you were told it.
Correct.
And you missed it, and then you sued the Feldmans over it, correct?
There was an action brought forth according to what I just read.
You sued the Feldmans over it, correct?
Well, if that's what that reflects, yes.
And I'm assuming that before the association files suit, that its officers and directors are involved in approving a suit. Am I correct?
Yes.
How much would you pay for Tilbury 2 lot today with the knowledge that it can never be built on according to the association's position? How much would you be willing to pay for that?
I wouldn't be willing to pay for anything.
Not a penny.
No.
To you, there's no value in that property, correct?
It wouldn't even be personally.
Not a penny, not worth a penny.
It would have no value to me personally.
Zero. Nowhere in Exhibit 00 or in Exhibit GG is there any reference or statement or words to the effect that if the owner of Tilbury 1 goes forward with the construction, Tilbury 2 becomes a pasture and an empty lot forever. Am I correct?
Correct. This dealt only with the approval of 5542.
By the way, where did you... I didn't see a letter to the owner of Tilbury 2 telling or advising the owner of Tilbury 2 of the impact of the construction on Tilbury 1. Did you see that letter?
No.
Where's that letter?
I said I didn't see the letter.
Have you ever seen a letter to that
I
effect?
have not.
So how did the association convey to the owner of Tilbury 2 that if the owner of Tilbury 1 constructs something on the property that, on the Tilbury 1 property, that the Tilbury 1 property becomes a pasture land?
Tilbury 2 becomes a pasture.
I'm sorry, that Tilbury 2 becomes a pasture land.
There was no letter.
Ever.
I said there was no letter.
I want to make sure it's clear for the judge and jury that your testimony is the association never wrote the owner of Tilbury 2 and advising the owner of Tilbury 2 that the impact of the approvals set forth in Exhibit GG and 00 and the beginning of construction on Tilbury 1 means that Tilbury 2 has to be a pasture land forever.
There was no letter ever given to the owner of Tilbury 2.
And no notice given to the owner of Tilbury 2, correct?
Correct.
Either orally or in writing, correct?
Correct.
Did it say somewhere in here, in Exhibit II, that if you pour the concrete, Tilbury 2 can never be used for any purpose?
No.
Did you give notice to the owner of Tilbury 2 in Exhibit II that, or anywhere else, that Tilbury 2 can't be used for any purpose once you pour concrete?
No.
And did you give notice to the owner of Tilbury 2 in Exhibit HH that there's an issue out there that if the owners of Tilbury 1 go forward with the construction, Tilbury 2 can't be used for any purpose?
No.
And by the way, there's nothing in Exhibits OO that says or implies that if the construction on Tilbury 1 goes forward as approved in Exhibit OO, as it was approved in Exhibit GG, as it was approved in HH, and as the form survey was approved in II, that Tilbury 2 could not be used for any purpose.
Correct.
But the association demanded that the Feldmans obtain an amended plat.
Yes, that was part of the process, yes.
And the association demanded that the Feldmans obtain an amended plat as a precondition to beginning construction.
Correct.
But your position is, as you sit here today, am I correct, for the purposes of the judge and jury, is that even though the city of Houston issued its amended plat, reviewed the restrictive covenants, and issued not only amendment number 1, but amendment number 2, that doesn't change the plat for purposes of the restrictive covenants?
That's my understanding.
That's your position.
It's my understanding.
Is that your position as the corporate representative
It's
of
my
the...
understanding.
Let me try it again. Is that your position as the representative of the association as you sit here today?
Yes, that's my understanding of what the law is.
Notwithstanding Mr. McConn's statement to the contrary.
Correct.
Do you know that the owner of Tilbury 2 is Mr. Michael T. Kelly,
Yes,
trustee?
that's what our records reflect.
Could you please turn with me to Exhibit ZZ?
ZZ?
Yes.
Okay.
And this document entitled Invoice in the large bold lettering in the upper right-hand corner, what is this document, sir?
That's our invoice for the maintenance fees.
Okay, and to whom was this invoice addressed?
Michael T. Kelly.
And what day was this invoice issued?
12/1/09.
And since this address is here, do I understand that it was sent to Mr. Kelly at this address?
Yes,
And to your knowledge, was this invoice paid?
I believe it was, yes.
Okay. If an association were to put, and I'll use this word loosely, an encumbrance, but restraints as to a particular home, would that affect the ability of the homeowner to sell that house?
I would think so.
Yes. In your common experience, if somebody came along, a legal authority of any type, or anybody who had standing to go into court and said, we want to knock down your house, you as the seller of a house, I mean, you would have to be disclosed, right? I mean, if not, you'd be liable
Yes.
for fraud if you didn't tell potential buyers about this. What would that do to the resale value of the house?
It would substantially impact.